How about like a bike path? You know, a lot of people ride on bike paths, they're expected to use it, and there's something wrong with the defective in the bike path. Does somebody have a cause of action against the party that's maintaining that bike path? Probably it's usually, I would assume, a county or a municipality.
Here's where the phrase that everyone hates is going to come out. It depends. It depends on who owns the bike path. If it is a designated bike path, then you are, as Ron said, an intended and permitted user. So the standard then becomes reasonable care for whoever owns the bike path. But there's immunities in our state. The counties have immunities, the city has immunities, and those immunities may, they wouldn't prohibit a suit, but they might make a suit more difficult.
So that's why in most cases, even though we're generally talking about the legal issues here, our viewers should understand that if you have a specific cause of action, you have to see an attorney and specific facts for each particular case on any discussions that we have. So although we're generally talking about the law, they should be aware that it's important for them to go see a lawyer. Would you agree with that?
Absolutely. You know, every case is different, and there's, you know, depending on where it happened and how it happened, you may or may not have a claim to make, so it is important to.
Okay. How about if we move on just to an issue of, you know, you fall in a business now. You go to a business, you go to whatever, your shopping center or something like that, and there's, you go into a store and you slip and fall and something like that. Is there a difference in that versus a homeowner's? I mean, what kind of issues are involved in there? Is there any topics or statutes on? I know there's something about a business invitee or something like that. What are we?
Well, years ago, they used to make a distinction between your status, whether you were a trespasser or an invitee or a business invitee. But in the, I'd have to say about a dozen years ago, the statute was changed, and now the standard again is reasonable care.
So the business invitee, the person who owns the property, has a standard to make sure the premises are reasonably safe for whoever it is?
Correct. Just as if you were walking into my home, if you were on my sidewalk and you slipped and fell, I'd have the same duty as someone from a grocery store would if you were walking into their entranceway.
And I think an important distinction in those kinds of cases that involve slipping or falling in someone's property, whether it's a homeowner's property or in a business, that you have to be able to show that whatever it is that caused the person to trip or slip was there for a reasonable amount of time, that the business owner, let's say, for example, knew or should have known that it was there and they cleaned it up. A good example is, you know, you're walking through a grocery store and the person in front of you throws a banana peel over their shoulder, and then the person behind the person falls on this object. In that situation, I don't think you would have a case, because the business owner certainly didn't have reasonable notice of whatever it is that was on that floor that caused you to be injured.
If somebody is injured in a premises, would you recommend to them that they talk to somebody, or at least let somebody know about the situation for whatever reason?
You're talking about at the premises?
Yes, at the premises.
You certainly want to give the manager or somebody make a record of it, so that somebody from their business knows that something happened. And it's always a great idea to, if you see people around that saw the incident, get their names. And that's sometimes hard to do when you've been injured, but it's very helpful to have somebody there that was an eyewitness to what happened.
How long now do you have to file claims like this for premises or things like that? What's the statute for filing something like that?
Well, the technical term is statute of limitations. And in Illinois, generally torts, you have 2 years.
Okay.
And that's 2 years from date of injury.
And there's some exceptions to that. You know, if you are a minor, or if you're disabled, or if you did not know that somebody was careless for whatever reason, there are exceptions to that rule. So again, a good rule of thumb is, you know, if you think you have a case, you need to see an attorney or make sure that your rights are protected so you don't lose that.
Now, how about
When we talk about disabled, it's legal disability. So again, to make your point, it's probably a good idea to talk to somebody, talk to an attorney, make sure you're on firm ground.
And how about from the standpoint of maybe the business owner themselves? Somebody gets injured on their premises. What kind of investigation would be a good idea to do to protect them for their, you know, insurance company or notification? Would you suggest for them?
Well, one of the things, just to touch on something that they mentioned earlier, is Ron mentioned the banana peel example, but also one of the things you're going to be looking at if there's an injury that occurs at a business or something is also, is this an open and obvious condition? Is this something that the person should have seen? You know, are there signs up, you know, wet pavement, wet floor, things of that nature? Because you also have, when you're going onto someone's property, you also have a duty to be looking out for these sorts of things too. As far as what types of investigation, you would want to, some of the things he said, you know, get witness statements, talk to people who were there, try to figure out what happened, examine the scene, take note of it, you know,
Pictures maybe, or whatever
right,
it is,
pictures,
see what they slipped down,
diagrams,
or whatever it might be.
have maybe the person who was injured write out a statement, just to sort of get an idea of what happened while it's fresh in
Protecting
everyone's
the business
memory.
owner. I know sometimes they have cameras and things like that too.
Right.
Maybe a good idea would be to look at the video cameras and
Correct.
things like that.
Right.
Okay. You know, I think we're gonna take just a break for about 1 minute, and we'll be back with our discussion on personal injury claims. I'm Sam Kavathas, and my guests tonight are Susan Zwick, Ron Kalish, and Lisa Velez, and we're talking about personal injury claims, and we'll be back in just a minute.
Bye, Tyler.
Bye-bye, Tyler.
Dear, it's time for serious talk
Oh?
about my daycare. When I started out, it was just to help the neighbors. But lately, it's getting to be a real handful. I need some help.
What can I do?
I need advice on more space, a loan,
What about incorporating?
and insurance.
Wait, I know who we can call.
Times like this require sound advice. Your lawyer can help. A message from the Illinois State Bar Association.
It's your fault! Never!
Over and over,
It's our problem! Leave me alone! Shut up! Out!
time and again,
No! Drive me nuts!
Shut up! You're the dumbest
generation
kid in the whole
after
world.
generation.
I hate you. I hate you too.
Isn't it time we stop the cycle? Now.
I hate you. I hate you.
Stop adult violence. Teach kids peace. A message from the Illinois State Bar Association.
Welcome back to the Illinois Law, sponsored by the Illinois State Bar Association. I'm Sam Kavathas, and I'm your host for tonight's program, and we're discussing personal injury claims with my guests, the Honorable Susan Zwick, Ron Kalish, and Lisa Velez. And we were just finishing up issues about business invitee, or injuries on the business and what the businesses could do to protect themselves. And I think you wanted to add something in there.
Just a footnote. The idea of information gathering by both the person who may be injured, a witness, or the business owner. The more information that's gathered, the easier it's going to be to let the facts come out, and if there is a dispute, if there is an injury and a dispute, you can go ahead and resolve it. If the questions are answered and the facts are there, it's much easier to seek a resolution than it is to seek a lawsuit.
Yeah, you know, in business situations where you have a business injury like that, I see it all the time where, you know, time goes by, employees don't work at the company anymore, witnesses move, phone numbers change, and that's a great point. If you get those facts and everyone can agree on those facts, hopefully, you know, things can be worked out without a lawsuit.
Okay. The second half of the show, I'd like to move on to auto accident cases, because usually somebody's involved in some kind of auto accident cases during their lifetime. So let's talk about that. What happens, let's talk first about the person who's injured. You know, I'm injured in a car accident, and questions that people always ask is, what do I do? Who pays my medical bills? A few things like that. And maybe we can start out with some of those simple questions as to what do you do when I'm involved in an accident?
From a defense perspective, the first thing you'd want to do if you're involved in an automobile accident is to notify your insurance company. Let them know that you've been involved in an automobile accident, because usually if you end up being sued, they're going to provide you with counsel, but one of the things you need to do is to make sure that you're cooperating, and one of the ways to do that is to let them know that there was an accident, and you know, just to sort of get the ball rolling.
Is that so they can also do their good investigation
Correct.
early on to get all the facts of what's going on?
Correct.